This is Dr. David Schein, and welcome to Business Law 101. In terms of jury selection, I mentioned in the earlier class that there's a TV show starring Mark Harmon called NCIS. In that show, Mark Harmon himself starred as the lead character, and the number 2 character in that show for many years was Michael Weatherly. He left NCIS several years ago to star in a TV show called Bull, B-U-L-L. And the idea of Bull is that he is a jury consultant. Now, the problem with the show is that he acts like a Perry Mason and a insurance investigator and a coach for the parties and all sorts of crazy stuff that has nothing to do with being a jury consultant. So, but in any event, there's actually a TV show. I think it's still running. I don't know if it is. Terrible show. But the idea is that he helps people pick juries who are more likely to rule in favor of the client who hired the jury consultant. That's completely legal. It's a legitimate thing. For most of us, we pride ourselves on being able to pick a good jury. So most of us don't use consultants. Also, it's expensive to use a jury consultant. So it's more likely to be used by a rich person who, say, is up on criminal charges but can afford to pay a jury consultant and maybe help them get off on the case. And then you've also got a situation where in civil cases where there's millions of dollars at stake, it may be worth it to hire a jury consultant to make sure that on the jury, like if it's a medical malpractice case involving a device, that you don't have people on the jury who've lost a family member or are really rabidly against a medical manufacturer. So you want to try and weed those people out. And that is called the voir dire. Voir dire is the correct pronunciation. It's rarely used in Texas. You're going to hear, here in Texas, you're going to hear every pronunciation under the sun for voir dire. And then can you get rid of people? Number one, if someone expresses an obvious bias while you're doing the voir dire, you're asking them questions and they say, well, I hate people who look like this, or I hate businesses or something. Usually you can go to the judge will throw that person off the jury. And then there are something called peremptory challenges. Most of the time, each party gets 2 or 4 free, basically get out of jail free cards to object to people on the jury that you feel would be against your case, but that you cannot express a for cause reason to get them off. And it's been determined through case law that at some point, public prosecutors would exclude people if there was a person of color accused of a crime. The prosecutors would go in and remove everybody who was that color from the jury. And subsequently, it's been determined that created an unfair jury. So you cannot strike jurors on the basis of their racial identity. Now, if they say something racist and you feel that they would be very unlikely to make a fair decision, certainly you could exclude people on the basis that they were racist, but not on the basis that they belong to a particular color. So something to think about. But again, for cause or peremptory challenges. By the way, when I did do trial work, I found that it's very hard to get the judge to take people off the jury panel for cause. So the judges don't like to do it, and they're like, well, you got peremptory challenges, use those peremptory challenges, don't look to be to bail you out. Jury instructions are very technical and designed to keep the jury up to date on what they need to do. Verdict is a decision of a jury. If you're having what's called a bench trial, which means the judge is sitting without a jury, then that will be simply a judgment